All yours.
Ready?
Yes.
All right, we'd like to call the Real Estate Appraiser Commission to order for the month of January 2018. Do we need to take a roll,
Yes, I'll be happy to do that.
please?
Ms. Rosemary Johnson?
Here.
Chairman Randall Thomas?
Here.
Dr. McCara?
Here.
Mr. Rex Garrison?
Here.
Jim Atwood?
Here.
And not present with us today is Jason Bennett and Mark Johnston. Thank you.
Any others, the vacancies are still vacant, right?
Yes,
Or the
that is
seats are
correct.
still
We've got
vacant?
one still vacant, and
Okay.
yes, no updates yet.
Okay. Do I hear a motion to adopt the agenda?
So moved.
Second.
Moving second. That doesn't call for a vote, does it? Okay. Roxanne, you want to take the Roberts Rules of Order?
Absolutely. Thank you, sir. This is our first meeting for 2018, so in conjunction with what all the other regulatory boards, we want to make sure that our procedures follow Robert's Rule of Order, so we would need a motion in order to proceed and a second. And if there are any questions on how that takes place, Sarah will be happy to explain, but normally otherwise, we follow the standard Robert's Rules every year.
So moved.
Second.
All right, motion been made and second to follow Robert's Rules of Order. All those in favor say aye.
Aye.
Any opposed? Carried. All right.
Thank you. And next on the agenda, also a little bit different than our regular meetings, because it's the first meeting of the year per statute, we need to elect a chair and a vice chair. And so I would put it to the board, the commission for conversation. Any nominees for one or both positions, and then based on those names, we will do a vote to make sure it's an agreement. And then if there's any other suggested name for either chair or vice chair, we would do a second vote.
I'd like to nominate Randy for the chair and Rex for vice chair.
Second.
Now, Rox, you handle this, right?
I sure do. I
Okay.
sure do. So we have a motion to re-elect Mr. Randy Thomas for chair of the commission, and as vice chair, again, Mr. Rex Garrison, and by roll, correct?
Yeah.
So by roll, I will go through. If you are in agreement, you would say yes, and if not, we will take names again a second time. Ms. Rosemary Johnson?
Yes.
Mr. Randy Thomas?
Yes.
Dr. Warren McCara?
Yes.
Mr. Rex Garrison?
Yes.
Mr. Jim Atwood?
Yes.
All in agreement, so we have for 2018 the same chair and vice chair. Thank you.
You can get it right this time.
Thank you. Now, just to clear up something for my personal benefit, do you have at your hands there the schedule of meetings for next year?
I do not, but we can pull them and get them to everybody.
Okay.
To make sure you take home in paper, or would you like me to email them tonight? I have the next meeting for April 16th, but I do. Okay, yeah,
Yeah, kind of
We'll
like,
get
to
to.
be quite honest with you, I kind of like both.
absolutely.
That way, so I just don't want somebody saying I didn't get them.
Sure.
We either
We
got
will
'em-
email them to everyone tonight, and then Dennis will come back with paper copies, so you can take them with you. Thank you. The next
Is there, you done?
Yes, I'm all done. It is back to you, and we are reviewing the minutes for November to make sure that they can be approved.
Has everyone had a chance to read the minutes from November 28th?
Yes.
Anybody have any questions or comments? Let's take a vote to approve the minutes from November 28th. All those in favor say aye.
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 Any opposed? Motion on the minutes carries. Experience reports. I do not have in front of me, let's see, Jim, you did one?
Mine was an informal conference.
Okay. Rex, you did one?
Yes.
Okay. Yours was a 500 hour?
He has, yeah, he did.
Okay,
Yeah, 500. I had 500.
okay.
And
Go
on
ahead,
your
Rex, I'm-
iPads, I think they start on page 29, if we can make sure to not miss any. You also have on the iPads a direct link. If you press on the word, it'll take you to that exact page.
29?
Yes, sir.
Sorry for the delay.
Problem.
Okay. Again, I'm sorry. Go ahead, Rex.
I've reviewed the reports by Jason Lopes, and I found them to be satisfactory, and I recommend we accept them for his license upgrade to a certified general.
All right, you've heard Rex's recommendation on Mr. Lopes. Anybody have any questions for him? All those in favor say aye.
Aye.
Any opposed? Thank you, Rex. And do you have another one?
It was a 500 hour.
Okay. I had one, I had two. Now, these are, the two that are on here are the two that I interviewed off-site,
Correct.
okay? And then I had two today.
Right.
Mr. Gregory Atkins, going from trainee to I thought both of them were going to where's Dennis? I thought both of them were going to license. This says certified residential. I'm pretty sure both of them were going to license. Let's go to Glenn McDonald. I interviewed Mr. McDonald. He's well-versed in what he's supposed to be doing, knowledgeable, and his reports were in line. So I would recommend approval on Glenn McDonald from trainee to license. All those in favor? Anybody have any questions for me about Mr. McDonald? All those in favor say aye.
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 Any opposed, vote no. Roxanne, I'm going to wait just a minute until Dennis gets
On
back.
Atkins?
Yeah.
Yes, let's do the other two that you did while you were, Benjamin Floyd, and then the second one.
Okay, they already have recommendation. Okay, the recommendation
vote.
is to approve Benjamin Floyd. I met with him off-site, and Clinton Blatter, I met with him off-site. Both are very, very knowledgeable and very up-to-date, and I would recommend approval on both of those. Let's take Mr. Floyd, Benjamin Floyd. Any questions? Going from trainee to license, all those in favor say aye.
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 Any opposed? Okay, and then Clinton Blatter, going from trainee to certified residential, he was very well versed. I recommend approval on him. Any questions for me? All those in favor say aye.
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 Any opposed? All right, approval. Now, Dennis, I have a question for you. It says here, Mr. Atkins was going from trainee to certified residential.
Yes.
I thought that was, I'm almost sure he told me license. Both of them said license.
I can double check.
Okay.
I'm pretty sure it was residential.
It is residential, but you're saying certified residential?
Yeah.
Okay, because
It's-
I'm almost sure he told me license.
No,
Anyway,
the only one, the other one was licensed.
Okay.
Glenn McDonald was licensed.
Right, we voted on him, right, I remember that.
Yes. Glenn
Okay.
was licensed, but Atkins, I'm pretty sure, is residential.
Before we vote on that, I want you to clear that up for me. I want
Okay,
you to check.
okay, I can-
Okay, we'll put that off for right
Okay,
now, if you
that's no
don't
problem.
mind. We'll come back to that, if that's okay with everybody.
Yes, absolutely.
Our education report is next. Dr. McCara, could you tell us about our education report, please?
If
Yes.
we could, I'm sorry, I hate to interrupt you, but on the experience interview, we still have two, I believe, that Mr. Atwood got done and one that Rex did, or did you want to come back to
There's
this?
a 500
Those
hour.
were 5.
Okay, so they're fine as they are.
They don't need any vote.
Perfect.
Thank you.
Okay,
Want to make sure we didn't miss anything.
okay, sorry. Dr. McCara?
Okay, I have the education report for you. You'll see that there are 10 course proposals. All 10 of the course proposals are for continuing education only, and also all 10 of the courses are presented in traditional classroom instruction. There are 4 individual course proposals, and again, all of these are for continuing education. And there's one course instructor approval proposal. I should mention that there were one of the instructors for course 2114 and 2121, as well as the applicant for the course instructor, checked the box that they had been disciplined by a licensing or certifying body. But at least in my reading of what the situations were, I don't think they rose to the level that would make them unqualified for approval. So I am recommending for approval all 10 of the course proposals, or all 4 of the individual course proposals, and also approval for the course instructor.
Hearing Dr. McCarro's report to approve. Anyone have any questions or discussion? All those in favor say aye.
Aye.
Any opposed? All right, motion carries. While we're on the education report, I'd like for us to entertain the conversation or a discussion in regards to, because, for example, the courses that we approved today were 10 continuing education. I've gotten several phone calls about qualifying education being 100% contact hours. Is that law?
So your statute doesn't specify, but your rules say classroom, and that's been interpreted by this commission in the past as classroom hours. The new rules that we're not presenting today, because they're in an internal review process currently, they changed that to say course. Therefore, it can be online 50% of the time, which is what we voted on a few months ago. But that's
We
been
didn't
proposed.
vote on that,
You proposed to draft the rules.
Okay.
So we've
but
drafted.
it hasn't been approved.
We've drafted the rules.
Okay.
They're being reviewed by the assistant commissioner before they can be presented to the commission. So they'll be presented at the next meeting.
So I was going to ask, so you're anticipating at the next meeting, those will be,
We'll be presenting
Okay.
rules that essentially change the word classroom to course, and then kind of puts a little modifier in there that says up to 50% can be taken via distance learning online.
Okay.
So it would allow continuing education and qualifying to be 50% online and the rest in classroom.
the reason I asked that is because I've gotten 2 phone calls, as well as one of the gentlemen this morning who went to San Diego and to Chicago to get qualifying courses. And at home, one of the gentlemen said that there's nothing even offered in East Tennessee until like April. And so he's sitting around trying to figure out, do I want to spend the hotel room, the flight, and everything to go to Dallas,
Right.
or wait until, so that could ease some of the problems that we have, or some of the concerns we have as far as some qualifying education. So we'll handle that at the next meeting.
At the next meeting, yeah.
Okay, very, very good. Dennis, is it licensed or certified? It is certified, okay.
I think this is what you got confused. Glenn was licensed.
Right, but I thought both of them told me licensed, but that's okay. If it says certified, that's good enough, because his wife is his supervisor, so he's in trouble to begin with.
Must have made him really nervous.
So are we good going back to that and wrapping it up and voting?
I'm going to ask, is it okay
Yeah,
with the
I think
membership
so.
if we go back to the experience reports? Does anybody oppose that? We're going to go back to the experience reports and talk about Mr. Atkins. He's going from licensed to certified residential. I did that. He's well-versed. Like I say, his wife is his supervisor. So, anybody have any questions about the approval? If not, all those in favor, say aye.
Aye.
Any opposed, say no. Okay, thank you very much. Do you want to go any further, Sarah, into the proposed rules?
I know Roxana's going to talk a little bit about them later, so we'll probably hit on that a little bit later.
Okay, so now we want to go to the legal report.
Yeah, that's okay.
Can I ask you a question? I was looking at the 2018 Tennessee Real Estate Appraisal Commission members, and according to this, my term expired in 2017 in June, so Am I still a member of this commission?
I will tell you that the statutes say that you are to serve until someone is appointed in your place.
Okay. I
So-
thought I had another year, but that's, you keep the record, so that's fine.
And we can double check on it because I know
Yeah,
sometimes.
would you please? I thought I had it through this year, but
think-
I'm happy to serve until.
I think
Now,
Rosie's been expired for
I
some
assume
time.
that,
It's showing
either-
18 on here.
Okay.
But I
Okay.
was September.
Either until someone is appointed in my place or until I'm dead, okay? Is that, whichever comes first?
Yep.
Okay, all right.
We need to make a motion to accept the recommendation.
You'd get a nice thank you
Experience
letter.
interview recommendations.
did.
You did?
Yeah, we did.
Hey,
Yeah.
Dennis, can you call Robin? So for the legal report, we're going to call Robin. She's working from home. She had surgery in November, I think. And so she'll be able to answer any questions on her legal report. She's worked from home for a couple months now, so we've just been calling her for questions if you have any.
Okay. And in regards to the legal report, let me ask the commission this: have all of you had time to read these? Okay.
Robin, it's Dennis. Are you on?
I am.
Thank you, ma'am.
Hi, Robin.
Robin,
Robin?
can you hear us?
Robin?
Robin, can you hear us? Robin, can you hear us? Try to hang up and call her again.
While we're waiting for Robin, let me just say that in the legal report, if you have read them, number 1, number 5, number 6, number 7, number 9, and number 11 have all been, the recommendation from council is to dismiss. They need to read those in one at a time.
Just the complaint
Just the
numbers.
complaint.
Because then, once these minutes are approved at the next meeting, they'll be posted for the general public to see it.
Okay, so do we need to vote on those one at a time?
However you prefer. If you
Okay.
want to handle the dismissed, if there's no additional questions, that's the main reason I always like emailing them
Sure.
early so everyone can
And that's
see
why I
them.
was asking, make sure
We
everybody
can
read
get those
them.
out of the way. If everyone's comfortable with the dismissal, there's no reason to spend a lot of time on them.
Okay.
Yeah.
So we have number 1, number 5, number 6, number 7,
One
number
second.
9, and number 11.
Robin, you with us?
I am.
Okay, good deal.
7, 9, and 11.
1, 5, 6, 7, 9, and 11 are, the motion is made from council to dismiss.
I would request that we eliminate number 11 from that. I'd like to discuss that one.
Okay. Anybody have any other discussions or that you want to go over? Rex, Doc?
No.
Actually, I actually have questions on several of them.
Okay, we'll just take them one at a time then. That's
But
that's absolutely no
quick
problem.
questions.
That's no problem.
Some of them are quick questions.
Okay. Robin, are you there?
So I'll
I
read,
am.
Robin,
Okay.
okay, I'll read the complaint numbers in, and then you can either vote or ask questions, and Robin can answer them on the first. I think she has 12.
Okay.
So number 1 is 2017055201.
Okay. Motion on that is to dismiss. And anyone have any questions?
Actually, the question I have on several of these is the same question. Several of these were not reviewed by an expert. I guess my question is why?
So if we feel that it's not an issue with the actual appraisal itself, we don't send them to an expert.
It is made in your office.
Yes, that's legal's decision.
Okay. Motion on number 1 is to dismiss. All those in favor say aye.
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 Any opposed? All right, dismiss on 1. Number 2.
2017057051. The recommendation on this is a letter of warning.
Any questions? I have a couple questions. You there, Robin?
I am.
Can you tell us, was this money ever returned?
I don't know.
Okay,
I can't tell. Yeah, I can't tell whether it was returned or not.
okay. And my other question would be, what exactly is a letter of warning going to say? Because this looks more like it's just a matter of a business decision.
It might be. It's just the letter of warning might say that you have to be sure you're following all the rules and regulations when you're dealing with a complainant, and that you should do things on a timely way.
Okay,
I think we've had something like this before, and we've just chalked it up. It's more business than anything else.
I'd have to agree. Something that
And he had some things
we need-
going on
yeah, that
personally.
we need to adjudicate over.
Yeah.
And keep in mind that we do post the letters of instruction and warning on the registry, just as a decision. So that it's a letter of caution or instruction, but either way, it would be posted.
Let me ask you a question about that too. When a person receives a letter of warning, and they're filling out their application for a course instruction or something like that, do they have to check the box to say they've been disciplined if they've gotten a letter of
No,
warning?
it's not technically discipline.
Okay, thank you.
I move we dismiss this case.
We have a motion and second to dismiss number 2. Any further discussion? Robin, you want to add anything?
No, that's fine.
All right, motion's been made and second. All those in favor say aye.
Aye.
Any opposed? Okay, motion carries to dismiss number 2 also.
Number 3 is 2017-057-091. The recommendation on this is a letter of warning.
Any questions?
Move to accept.
Second.
Motion been made and second to accept the council's recommendation. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Council's recommendation carries on number 3.
Number 4 is 2017-058-731. Recommendation is a $1,000 civil penalty and a 7-hour course in report writing to be completed within 180 days.
Any discussion?
Yeah, I found that to be a little steep.
Okay.
Do we need to go that far? This is an individual who's had no disciplinary history prior to this. I don't see anything that's minor clerical errors. It says doesn't. I don't know specifically what that is. It's not made available to us what specifically that is. Personally, I find the $1,000 civil penalty to be excessive. I would move to strike that.
Completely, or are you talking about a reduced amount, Jim?
Completely. On the first offense, I don't see anything here to fine them a civil penalty at all on the first offense.
What about the course requirement?
7-hour USPAP course is required anyway.
Sorry,
this
she
is
changed
for
that to
report
report
writing.
writing.
Oh, did I miss that somewhere?
That might have been in the we got a second version of the case.
Because I talked to Robin and told her that was required every 2 years, and so he had just taken it in February of 2017. So
Yeah, mine also says the USPAP course.
yeah, if you printed off what originally came, yeah.
Right.
The motion's been made to strike the $1,000. Do I hear a second?
I second that.
Okay, motion been made and second to strike the $1,000 and to require a 7-hour report writing class.
I've checked. There are plenty that they can take.
Okay, okay,
Trust me, we are double checking and
Okay.
triple checking that now.
okay. So the motion's been made and second. Any further discussion on the elimination of the $1,000 fine? All those in favor of the new recommendation say aye.
Aye.
All those opposed, the new recommendation carries.
Number 5 is 2017-062-511. Recommendation is to dismiss.
Any discussion?
It's the one that's combined with the trainee. No, that's not the one.
Yeah, this one is training the registered trainee in number 6 below.
Oh, those two go together. That's the one I'm thinking about. Okay, and you have, again, there's no review report here. No expert witness report.
No, not on this one. Robin, did you make that call on this one not to send it to an expert?
I can't recall, but the issue was not with the appraisal itself. It was the issue really not with the appraisal itself because it was adequately addressed by both the trainee and the report. So there was no recommendation to have an expert review it. I think the issue with the complainant was that there was a trainee as opposed to the this particular respondent, that it was a trainee doing a lot of the work. That was the major complaint.
That's typically how we make our calls. If it's actually a complaint on what's in the appraisal, then we'll send it off to an expert because, we can't make those decisions ourselves. But if it's something that seems like we shouldn't spend the time or the money to send it to an expert when we can make the call, that's when we do that.
I also had a question on this one, and that was just simply, we don't know that the complainant was an appraiser also, do we?
No, we do not.
Okay, from reading this, it appears to me it's more than likely a homeowner, whether it is or whether it isn't. But I just have a hard time when it says a complainant states that the appraisal was not completed correctly. My first thought is I want to see what your credentials are so that you know what a correctly completed appraisal is.
I agree, and generally if that person is a licensee, I do put that in there.
Okay, good. All right, recommendation on 5 is to dismiss. Do I hear a motion?
I move we accept.
Okay, motion's been made to accept. Second?
Second.
Motion been made and second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries.
Number 6 is 2017062531.
Was 5 and 6 tied together, you said?
Yeah, this is the registered trainee for
Okay.
the respondent in 5.
Okay.
Move to accept dismiss recommendation.
Second.
Motion been made and second to dismiss number 6. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries to dismiss number 6.
Number 7 is 2017067431. And the recommendation is to dismiss.
I move we accept.
Motion been made and seconded to dismiss number 7. Any further discussion? All those in favor say aye.
Aye.
Any opposed? 7 is approved to dismiss.
Number 8 is 2017069851. Recommendation is a letter of warning.
Any discussion?
Move to accept.
Second.
Motion's been made to accept council's recommendation on number 8 and seconded. All those in favor say aye.
Aye.
Any opposed? 8 carries. Number 9.
Number 9 is 2017070711. The recommendation is to dismiss.
Move we accept council recommendation.
I second it. All right, motion been made and second to dismiss number 9. Any further questions?
Yeah, well, just a clarification. Mentions red flags several times. And again, we chose not to have this one reviewed.
There wasn't anything. It just said red flags in the complaint, and I saw nothing in there that would require an appraisal review based on what was stated.
Yeah, the complainant was a homeowner who knows what a red flag is. I'm not saying they don't. I don't mean it to be that way, but I have a concern about that. Okay.
I'm not sure the homeowner knows what a red flag is because I think red flag is a term used by many of us for many things and not necessarily in a professional manner.
Sure. Thank you for the clarification.
Mm-hmm.
All right.
Also, I agree with that, but I also would just like to state that sometimes red flags do indicate something that would be necessary to have reviewed, and maybe should be reconsidered in a sense in this effort to protect the public trust. I'll vote to dismiss, but I just wanted to make that statement.
Absolutely.
Okay. So motion been made and second to dismiss number 9. Any further discussion? All those in favor of dismissal, say aye.
Aye.
Any opposed? Motion to dismiss number 9 carries. Number 10.
Number 10, 2017-069-291, and the recommendation is a letter of warning.
Any discussion?
This person has had some discipline history. They get a letter of caution. Is a letter of caution different from a letter of warning?
They're the same thing.
Okay.
Sorry.
If it didn't work the first time, do you think it'll work the second time?
I can't tell you what the letter of warning was on the initial letter because that's not something I can access
Sure.
here at home. I can tell you that the reviewer thought it was adequately described and didn't have a huge concern, but I think that a letter of warning saying, hey, this has been reviewed, you have some issues here, you need to be sure you're in compliance in the future, might be valuable.
I understand.
So this one was reviewed.
Yes. I understand that. I just wondered, is it 3 strikes and you get a penalty, or how does that work?
I don't think we have that. I mean, it's all up to you, and that's how we present it. I can tell you that as you can see from my report, if I think there's an issue there that ought to require something more than a letter or a caution, I will say so.
Okay. Regardless of how many previous letters of warning the person has had?
No, if I saw that there were 12 letters of warnings or 4 letters of warnings or 3 letters of warnings and it's all the same particular issue, then yes, I
Okay.
would say that's an issue.
Thank
Okay.
you.
Thank you. All right, you've heard council's recommendation. What's the commission's pleasure?
Move to accept.
Second.
Motion been made and second to recommend a letter of warning. Any further discussion? All those in favor of the recommendation say aye.
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 Any opposed? Motion carries. Number 11.
So number 11 is a representation from the November meeting. It's number 2017-043091. And it looks like Robin added some updated information for you all and recommended dismissal. This is on the conservation easement from November.
Number 11 has been recommended to dismiss. I just have a quick question. Has this person just been an appraiser since 16?
I don't think so. I think that was an older, but I don't have that information available to me.
This says 2016
It
is their
says
first
2016 was their first license.
Yeah.
And that's the reason we went back and asked for qualifications.
Okay.
It might be that that's the license in Tennessee. This particular appraiser has a license in another state as well, whereas he said, or she said, that it had done conservation appraisals in that state as well.
All right. Just for the fact that I wasn't here in the November meeting, I'm going to ask Mr. Garrison to make any kind of comments because he chaired the November meeting when this was first brought up. Can you enlighten us any, Rex?
Yeah, we sort of went back, wanted qualifications of both the complainant and the reviewer, and really that's what was done. And reading what came back, I would agree to dismiss this one.
Well, I have a lot of problems with this one. First of all, we have a reviewer that states he's not qualified to review this type of property or this type of appraisal. It comes back with all kinds of violations. The reviewer indicates that they had contacted someone who was competent to do this type of appraisal. But that name's not been given to us. We don't know who any of these folks are. So personally, I think there appears to be issues that need to be dealt with in this appraisal, but the reviewer was not qualified to do it.
If I might address that for a moment.
Yes, ma'am.
The appraiser appraisal was done by the reviewer, respondent. And in the process of that review, that respondent contacted another reviewer who was very qualified, as I said, there to do these types of appraisals. We sent it to an appraiser to do that. We don't have specific people online that do conservation appraisers. But I will tell you the review by the conservation appraiser in assisting the respondent in the first place was extremely well qualified. And the reviewer acknowledged that when we asked that reviewer that we hired, when we asked that reviewer about their qualifications. They acknowledged that the person that reviewed it for the respondent was extremely well qualified. That's part of the reason I say that this should be dismissed.
Explain that again. Why? I'm not quite getting the dismiss.
I know that I dismissed because I don't think there was any violation. The review was done by a person who was qualified to do conservation appraisals. In the process of doing that initial review, there was a third party, even more qualified, who assisted in the appraisal and gave the information that helped produce the final appraisal. It was reviewed by a person hired by us to do an appraisal. That reviewer stated that they didn't have experience in doing any conservation appraisals, and also stated when they saw the information about the third party that helped review it, that that person was extremely qualified to have helped and assisted in the first place.
Well, but the reviewer still has issues with the report, or I'm not reading this correctly. Reviewer states scope of work does not meet expectations of regular intended uses, is not sufficient. Revised report discloses use of hypothetical condition but does not adequately disclose what the effect of the use of the hypothetical condition is on the assignment results. So the reviewer still has issues with the report.
The reviewer had issues with the report. That is true. However, as I said, the reviewer states that it has no particular experience in doing this particular type of review on a conservation which may have different qualifications, as seems to be indicated by the person who did the professional review with the respondent themselves.
I'm just confused, but that's all right.
Well, hang on just a second.
I understand what she's saying.
Right.
My question is, has the state provided an adequate review? Do we actually have an adequate review on this report?
And we do not have anybody we have contracts with reviewers. I don't think anyone in that area had this type of experience that could review this. And we had some people that had conflicted out, so we used our reviewer that we could use.
Am I correct in saying the reviewer spoke to another reviewer, or the person who did the appraisal spoke to another qualified individual?
The person that did the appraisal had someone review their appraisal who was apparently very widely respected in this.
Okay, and is that person who contributed signed the appraisal also?
No, because that's not exactly what happened. In the process of doing this, the respondent consulted a reviewer on several issues just to make sure things were doing right. That reviewer that he consulted with is a professional and has vast experience doing conservation easements in another state, not in Tennessee. He's a licensee in another state. And the the reviewer itself recognizes that experience of that third party who helped the first initial person.
My issue with this whole thing is, has the state done due diligence to have this thing properly reviewed by a qualified reviewer who would give this board proper recommendations? Has that been done?
I think as Sarah stated, and I'm sorry, Robin, it's Roxana, I don't think that any of our reviewers that we have contracts with that we pay have specific experience in that area. So if the commission would like us to send it somewhere else, I guess the reason that Robin's going down this path, and you can correct me, Robin, is because the person originally that assisted in putting this together is an expert in that field.
That's correct. and that was recognized by this reviewer who reviewed it for us.
Okay. The recommendation on number 11 is to dismiss. Mr. Atwood, do you want to make any kind of motion?
I would make a motion that these reports be reviewed by a qualified appraiser, even if we don't have one on our approved list. We need to find one and have a qualified appraiser review these reports and give their recommendation. That's my motion.
Basically, your motion is to table this at the current time. Okay.
So I would say what we're going to need from you all, if you have anyone that you know that is an expert, I mean, you're going to have to send them to us, because otherwise we would have to put out a bid, and I mean, this could go on for
Months.
far longer than we want it to.
Okay, we have a motion on the floor to table the current number 11.
You want us to find an expert in conservation easements in this area of the state to review this.
Yes, ma'am.
Do I hear a second? Okay. Motion's going to die from a lack of a second. So the motion that comes, or the recommendation that comes from council, is to dismiss. Do I hear a motion from the commission to hear council, to accept council's recommendation?
So moved.
All right, motion's been made
Second.
and second to hear council's recommendation. Any further discussion? All those in favor say aye.
Aye.
All those opposed?
No.
Okay. Motion carries to dismiss. Then I just have a generalized question. When we get into situations like this where there are specialty properties, what is the normal procedure, or if there is even a procedure, to find someone who we can say, you know, this guy's got a complaint because he was doing Nissan Stadium, or
Right.
you know.
So typically what we do is, I mean, we have Lillian or Rihanna, they're looking at it to see what part of the state it's in. We have, you know, experts in each grand division, and we go to those people in that division to see if they have any familiarity with that area. Unfortunately, our experts in this area of the state, none of them had any expertise. And one of them said, I can do it. You know, I don't have the expertise, but at that point, we would have had to come before the commission and ask for you all to give us permission to go out and do maybe a one-time find an expert,
Sure.
which could cost us anywhere. I mean,
Okay,
Let's
this would
go
be my
over
question. Why do we have to
10,000.
find someone within that geographic? I mean, if this is a unique enough situation to where the neighborhood could actually be Tennessee or even southeast
Yeah.
United States.
I think I mean, we typically do it that way because a lot of people that are over in East Tennessee don't know anything about the properties in West Tennessee and won't review it for us. We've had experts up in your area tell us, I'm not familiar with places below Knoxville, and they won't review them for us.
Okay.
They just don't feel
But this
comfortable.
is kind of a unique situation,
agree.
so I just was kind of questioning
Yeah.
that.
And I mean, if you look at these in the future, I mean, we can bring them to you all right away and see.
Go ahead, Robin. You had a question?
Sure. Sorry. No, and I just wanted to assure you all, if there hadn't been an expert in this particular area who answered the questions of this particular respondent and was recognized as being a particular expert, my feelings might have been different as well. But there was somebody online who had particular experience, recognized by all parties as having not only particular experience, but being particularly well qualified.
Yeah. Okay. All right. Thank you very much. I'm sorry. Moving on to number 12.
Oh, so we can let Robin go now, but Robin, you should be at the next meeting, correct, in April?
Oh, yes. Unless somehow we do again, but I should be there.
Do you have a hearing on that date?
I believe I do. I think
I believe-
that's the one that was continued from the last time.
Perfect. So Robin will be here at the next meeting.
All right. Thank you.
Thanks,
Thank you, Robin.
Robin.
Appreciate
Thank you,
your help.
Robin.
Sure. Thank you.
Thank you. Number 12.
Mine, 2017056991, and my recommendation was a civil penalty for $1,000, and it says 22 hours, but that should actually be 21 hours of coursework, 7 hours of sales comparison approach courses, and 14 hours of report writing education courses to be satisfied within 180 days. And I made that recommendation because I felt like the violations heavily affected the appraisal, even though there doesn't look like there's very many. That first bullet point kind of summarizes many of them that in aggregate, the expert reviewer felt did heavily influence the appraisal report. And then there's two more underneath that. The respondent's been an appraiser for 23 years and has had no discipline, where I probably would have recommended a little bit higher civil penalty, but I thought the coursework is definitely appropriate here.
All right. Thank you, Eric. You've heard a recommendation on number 12. Any discussion?
Again, seems a little excessive to me. This is a first offense, again, no disciplinary history. I would move to eliminate the $1,000 civil penalty.
All right, motion's been made to subtract the $1,000 civil penalty from the recommendation. Do I hear a second?
Second.
All right, motion been made and second to eliminate the $1,000. We're only going to vote on the elimination of the $1,000 at the current time. All those in favor, say aye.
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 Any opposed? Okay, now let's go back to the recommendation minus the $1,000 penalty.
One of the things that stands out to me is, as was noted, this is someone who's had a lot of experience as an appraiser. And, you know, I would think that they would be well-versed in writing the appraisal. Maybe they just got into some bad habits or something like that. I mean, I'm trying to figure out what somebody who's had that much experience in being an appraiser would benefit from a course in report writing. It's not like this is a new thing to that person. I don't have an objection to it. Let's just throw that out as a question for the
Sure.
professionals here on the commission. That seem appropriate to all you?
I don't have an objection with it. The only thing I would say, and we ran into this, Sarah and the commission did, and I appreciate your correcting, but the 15 hours should be 14 hours, right? Right,
it should be
because we
14.
ran into that with one gentleman recently who had everything done, but he was 1 hour short because he could only find 7-hour courses instead of the 15, so I don't have a problem with this. Motion's been made and amended, minus the $1,000, to have a 21-hour coursework done, 7 to be sales comparison approach, and 14 to be report writing. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries minus the $1,000. Number 13.
017055381. And the recommendation is for just coursework, 7 hours of sales comparison approach courses, and 7 hours of highest and best use education courses, to total 14 hours to be completed within 180 days.
And this was reviewed.
Yes, this
Okay.
was reviewed, and this person was also an appraiser for almost 24 years, no discipline. I felt these violations were kind of technical. It was the first offense, so hopefully I did better on this one than the last
Says
one.
there was a letter of warning in 2016.
Yes, so I guess I don't call that discipline, but yes, you're right. There was a letter of warning.
Do we know, are we privy to what was the issue in 2016?
I could find out for you.
Or was there any crossover then to what the reviewer is saying now? In other words, has he committed the same offenses again?
I would have to look. I could do that. If you want to take a short bathroom break or something, I could come back with an answer.
I would like to know.
we can just postpone this number 13?
Yeah.
Okay. Take just a little break?
Yeah.
All right, let's take about a 10-minute break.
Thank you.
All right, back in session. Number 13, Erica.
Yes, okay, so to answer your question, Commissioner Atwood, the letter of warning in 2016 was regarding not using the appraiser stated the highest and best use, but did not summarize the support and rationale for that opinion, which is one of the problems, again, here, which is, I think, a good reason to have him do that 7 hours in highest and best use. But if you think a civil penalty is warranted, but that was the only thing included in this letter of warning. That was the only violation.
I sort of compared this to case 10, a very similar type situation. They had a letter of caution, similar type issues, and I was sort of weighing them on consistency on how we're doing it. But knowing that they didn't learn their lessons
And
then
it was just
on
May
the highest and
18th,
best use,
2016.
sort of.
I make a motion, we add a $500 civil penalty to what's already been stated.
Okay. Recommendation is we add $500 civil penalty to the recommendations from council. Do I hear a second?
I'll second that.
All right, motion's been made and second to add a $500 penalty to council's recommendation. Any further discussion? All those in favor of the recommendation as amended, please say aye.
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 All those opposed, amended recommendation carries. I believe
Randy,
that completes.
I'll tell you on the go forward, I think this is probably one of Erica's last meetings with us. You might be back one more time. You have one more, yeah. But then it'll just be Robin. They've kind of taken, so we don't have two. But I've talked to Robin via email, and we're going to do what we do with the Real Estate Commission. And what she'll do is she'll create technically 2 legal reports. One will be all of the dismissals, so that we call it a consent agenda for TREC. And they come in and review that, and they either adopt it as a whole or say, we want to take number 5 off and talk about it. And then we don't even have to worry about going through and discussing all of them unless you have questions on them.
Okay, good.
So it kind of speeds things up. I can tell you.
Idea.
When the Real Estate Commission went from 2-day meetings to getting out at noon last month, we were very happy.
Good.
Wow.
That's what I was trying to do to begin with, was to take all
Yeah.
those dismissals and just get rid of them.
Yeah,
Okay.
so.
Very good.
If I could add before we move on, since we're talking about the legal piece,
Sure.
at the last meeting in Washington that we attended, we talked with a couple of states that are doing kind of an expedited method as well with the complaints. And so Sarah and I are going to continue working on it. We hopefully will have something for the April meeting. A lot of our cases, even if you look at these, we either dismissed or they were all about education. And so the ASC has approved to other states, as long as the education that you're giving can be counted toward their continuing education to renew and not just about discipline, then we could move these in a much faster pace and consider them kind of agreements. And so we're going to look at what those states are doing. We're working closely with them. The ASC doesn't have a problem. It would move the complaints not only faster, but either way, we're coming to that conclusion to give them education only. Where right now the education is separate from their renewal continuing education, if we went this route, it would have to count toward it. So it's not just about discipline. And so we'll present that hopefully at the April meeting that we can review.
And then we can discuss that at the April meeting.
Absolutely.
Yeah, it's being discussed in legal right now to make sure that everyone is on board with doing that, because right now when we do continuing education that's above and beyond what's normally required, they have to sign a consent order with us, and so it is discipline. And so this would be taking it out of not doing a consent order but doing some type of agreement where it wouldn't be considered discipline. And it's kind of, I think Mississippi does it.
Texas does it
and
as well.
It's a way that they can get around where you can say, it would be like you saying, I don't think they deserve discipline, but I think that they need to focus their CE on the highest and best use. So it would be us giving them kind of a guided CE path instead of just, when I come back and tell you, oh, this person does no conservation easements, but it looked like they took, 15 hours of conservation easements and not any in highest and best use. And that's what they're missing every time. So it would be kind of a route like that where it wouldn't be disciplined and it wouldn't have to be reported on the National Registry. So that would be another thing, and they wouldn't have to report it to other states. So
That was my question. So that would not show up on the record as discipline.
Correct.
And when they
Correct.
file for like a course application,
They wouldn't have to
they
include
wouldn't have to check the
Right.
box that said that they've had
Or
discipline.
with E&O.
Correct. So, technically right now, what we're doing is they're all consent orders, so they're all considered disciplined, so they have to file it on if they apply to any other states for reciprocity, they have to include it, they have to send it to E&O. It's on the National Registry for the ASC. It's on our disciplinary action report. So, but it's being discussed in legal, so we're trying to make sure that if everybody's okay with it, and we'll bring it back to present in April.
Well, I assume there might be some circumstances where discipline would be in order. Is that correct?
Yeah, and that's kind of where we would have to figure out where we would draw the line. I think what would happen is it would kind of be Robin's call to say, this is maybe their first time, they have no discipline in the past. It looks like maybe if they just took a course, that might help, and so she would present it in that manner, where you all could still say, no, this looks really bad, we think there should be a civil penalty. So
That's what you lawyers get paid for,
Yeah,
is to
that's
split
it.
hairs, so that's good. Okay.
Well, and even the few that had civil penalties, at least two of those, we dropped the penalty, so that got me to thinking, and we'll try to get you something in draft before the meeting, so you
Okay,
can
good.
take a good look at it, but
Yeah.
it's
Good.
definitely something worth considering.
All righty,
we
proposed,
like our friends over in Mississippi. They send us good ideas
well, good.
sometimes.
Proposed rule change, or proposed rules.
So I was going to give you all just a quick, we have two sets of rules right now that are in the process. They're both with the AG's office for signature. One is the registered trainee, where we changed the rule based on our ASC audit. Unfortunately, that's been held up at the Attorney General's office, and I'm hoping it's just because they're busy, but I've been bugging them weekly, so hopefully we'll get those signed soon. And then the AMC rules, where we made changes from the bill that came through last year, those are over for signature. As soon as we get those back, we'll file with the Secretary of State, and they should be effective within the next couple months. The other rule, it's still being reviewed by the Assistant Commissioner, but I think Roxana was going to speak a little bit about that.
Correct, am I correct in saying we've already approved those rules?
Yes, you've already approved those rules. They've already been through our internal process, and they're with the Attorney General's for signature.
And so on the new round of rules that Sarah mentioned will include the qualified education that you had brought up, Mr. Thomas, and I think we've already discussed it. I had it on the agenda as part of this piece as well, so we've already covered it. And in there, we will also be adding fee reductions. And so that kind of transitions me into the director's report and the financial. What I did for everybody, and if you don't have one, let me know, is I printed in paper the last fiscal years, the 4 years of closure, so you can have an idea. So I won't go into details on recommended possible fee reductions, because once we have it in the rule, we'll be able to talk in greater depth. But if you look at your final number, when we closed on June 30th of 2017, we finished the reserve with over $2 million there. And it's, just been building. You can see it each time. So obviously that's a reflection that we're probably bringing in more than we need to. And so to be responsible, that's what we are going to be doing, is we've looked at all the different fee categories. So by the time we propose it at the next meeting, you'll be able to see what all we want to reduce so that it's fair to everyone, welcomes more people. And that's for you to take home. Sometimes it's good to have that visual as you're looking at the budget or making other decisions. So that's not on your iPads. Any questions about this piece? Okay. Along those lines, so on your iPads, on page 44, we start with the kind of the current budget and information that we have. And again, revenue's about steady. Our expenses, nothing drastically has changed other than the distribution of the litigating expenses for how legal is charged back to us. So that is not reflected on this month, that is through November, but I believe as of December, the way it's going to be distributed is not based on licensees and number of complaints, but rather their actual time. So bless Sarah and all the attorneys, similar to you, private practice, when attorneys bill back for their billable hours, they are actually looking at exactly what program they work in, how many hours, and charging it back that way. So I don't think the impact on this particular program will be big, but one of the things to keep in mind is when we go to conferences, the travel for attorneys is very important, obviously, and I think you all would agree that having Sarah or an attorney go that's going to be able to bring back information on changes is important, but then we're paying for all of that time, whereas before it was really billed differently. So we'll see how that impacts at the end of this fiscal year. So that'll be a change.
You want to move on to the director's report, or?
Yes, and we're sort of in it. So
Okay.
this would be the budget piece. I don't think that there's anything out of the ordinary other than, like I said, we're looking at those fee reductions. Those also came as a part of an audit that said, again, we have too much money, which obviously seeing an ending amount of 2 million kind of points us in that. So we will break down what it is we're reducing, but we're hoping to affect our renewals for our appraisers as well as those coming into the industry so that it's fair across the board.
Very good.
Okay.
What is a reasonable reserve amount?
Well, generally speaking, and it varies depending on chunk of expenses, things that, some boards have some educational things in there that they pick up. Probably not more than a year to 2 years worth of expenses. So if you look at your 4-year analysis, then our expenses are coming in roughly at, hold on a second, 400,000. So if we kept 2 years worth of that, we'd be still under $1 million that we'd want in that reserve to be conservative, and we've got double that. So, and we're definitely going to, keep in mind everything that we pay back out. So the ASC gets a good amount, and we know that our AMC fees are going to change a little bit as well as we look at that change in June of 2018. But at least right now, looking at what we have, we know we're taking in more than we need to. Good. Okay, I think we've covered on the AMC registry, as Sarah mentioned, there's some rules that we're waiting on some of those things. We've got on your iPads on page 47 is an explanation. Oh, it might be next. Yeah. If we can skip the letter to Mr. Parks and just go to the last piece so we can cover this. The change and implementation for the AMC is actually June of 2018, and so they've given us an extension to be able to have that go into place, and at the spring meeting, it's very possible that that will be discussed a little bit more as well, as far as the, I think it's $25 fee that they'll be paying for each appraiser that's on their panels. And so as we have more on that, we will reach out to you and then at some point discuss how this regulatory commission will audit that piece, because we'll have to define that. Okay. Last piece, if we could, let's go ahead and address the 2018 spring conference, and that is just so you could all see the dates. It is May 4th through the 6th of 2018 in Seattle. If we would like to go ahead and vote on commission members that would be able to attend, 1 or 2, and then again approve either Sarah and or I to go. I think May is going to be tough for me to attend if the commission's okay with Sarah going. We had discussed her going. Since she wasn't able to attend in October, I think it's really important that one of us be there, and I'm thrilled that her calendar is open. So if it's okay with the commission, Sarah would be going, and then I leave it up to conversation to see who else wants to attend.
Discussion from the commission. May 4th through the 6th, 2018.
I'd be willing to go.
Now, Doc, Jim?
I'm not able to go on those dates.
No.
Okay, here's the question. Do we send one commissioner, 2 commissioners, or how many?
Up to 2. So it's up to you all if you want to send 2 or if you just want.
I'm going to go. If you want to send me, that's fine, but if you want to send Mr. Johnstone, or somebody else, that's fine too, but I'm going.
I think since two can go, if the commission is okay with two going and representing being paid by the commission, that would be perfectly okay, since that's the most we can send.
In the form of a motion.
Yes, we will.
I mean, do you want us to reach out to Mark and see if he can go?
Yeah, I would prefer that you do instead
Okay.
of, yeah.
Because I know he had mentioned something about wanting to go to the DC, and then it didn't work out for his dates, so.
Right.
Yeah, just
Roxanna
ask him if he
shoot
can go.
an
If he
email.
can't go, that's fine, but I'm gonna go.
Yeah.
It doesn't matter to me.
We will need a motion to send, right now, we know Mr. Garrison, possibly Randy, if Mr. Johnston can't go and doesn't, fit into his schedule, and then Sarah would be going as well.
To put that in the form of a motion, please.
I move that we fund Mr. Garrison and also Sarah, and depending upon the availability of, who's the other one? Mr. Johnstone or Randy.
Okay.
Second.
Motion been made and second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Roxanne.
Okay. Let's go ahead, and if you don't mind, we're almost to the end, and then we're going to come back. We skipped over the response letter to the ASC. We've got a visitor here, so I kind of wanted to jump ahead because of that. Last on your iPads, I believe, or close to last, is the evaluation, which is on page 52. And this is regarding our evaluations and how to best put these Q&As on our website. And so feel free to come on out.
Yeah. Commission would like to recognize the Honorable Randy Button.
This mic is on, right?
Yes, sir.
Red, there
Testing.
you go.
Testing. Thank you, Mr. Chairman. I appreciate you giving me the opportunity to come and speak. I know this is a topic of discussion that and some confusion among practitioners across the state. And Sarah and I have had some conversations also concerning this. There's a couple of things that I want to kind of bring up that that I think are possible solutions to some of the problems. I know Commissioner Garrison has also been looking at some Q&As to be able to give some direction to the licensees across the state on whether they can do evaluations, how they do those, how they are conformance, because they get mixed signals from national organizations as well as possibly even the Appraisal Foundation and others throughout the country. One thing that, just to kind of bring us up to speed, we had a lot of topic of discussions in the very first Real Estate Appraiser Commission that I was a member of, and we put this provision actually in the original law, and there was some discussions with the Tennessee Bankers Association to be able to allow licensees to be able to perform evaluations, which was a needed service by federal-related financial institutions across our state. We thought we built in some pretty good provisions in the original law, and I think maybe Tennessee was one of the only states at that time back in the late 80s and early 90s to have a provision to allow that. One of the things that was specific in this, in the provision, was the evaluation shall be labeled on its face, this is not an appraisal, so that the public wouldn't be confused or clients wouldn't be confused as to what this document they were getting, which was an opinion of value, may have been performed by a licensed or certified appraiser, but this is not an appraisal. Now, what I see as a real problem is I'm asked by some of the banks that I do review work for to also not only review their appraisal reports, but also review their evaluations. We have a set of guidelines that we have to follow for evaluations, which are primarily interagency guidelines, but not USPAP as we would in an appraisal. And there are national companies or entities outside the state of Tennessee that are providing this service to institutions, financial institutions here in. And I'm just not I don't think they're aware that we have some specifics that need to be included in those evaluations, primarily that statement. So it creates a little bit of confusion or difficulty for those outside companies that are providing these evaluation services. They're not licensed and certified appraisers in Tennessee providing that. It's another entity that may not be licensed or certified appraisers. They may have different types of qualifications. The other thing that we run into is, from the review side, is when evaluations are for residential properties. They're really good at it. They're really good at what they do. They do analysis. Most of them that I've seen are really good. It's when they get into other properties, non-residential type properties, and they're providing these evaluations for those. A lot of times they don't have the knowledge or expertise to be able to provide those services, what we would call in our profession, competently. I'll give you a couple of examples. One is just did a review on a property that was a leasehold valuation, that an evaluation was done on a leasehold valuation. And I don't think the evaluator understood what's entailed in valuing a leasehold. This property only had 8 years left on the lease, but they valued it as if it were 1 year income, like a leased fee valuation, where their owner would have a reversion at the end. Well, the owner doesn't in this case, because they're doing the leasehold valuation. And once that lease is over, that developer owner has no value in the building. That reverts back to the landowner. This was a land lease situation. I don't mean to get into too many specifics, but to tell you what the result was this, that they valued it for about $1.4 million, when the true value just on those incomes over the next 8 years was about half of that. So the financial institution, they probably don't have the expertise. They're lucky that they are getting reviews of these evaluations, but these are kinds of things that are happening throughout. I mean, we see numerous special use properties, hotels, where they'll do an evaluation on a hotel, but they don't understand the valuation of a going concern and the allocation of those value components. So this is a problem. This is not a problem that's just isolated here in Tennessee. It's across the country. So the evaluation companies, they're really good on doing these residentials, but they're willing to take evaluations on other properties that they may not have the competency or expertise in those property types to be doing evaluations. Now, I know that's a lot of talk, but one of the solutions that I've been talking to someone, actually one of your board members that's not here today, had a really good solution in that establishing qualifications for evaluators. Now, I know we license and certified appraisers, but there are some valuation, since you're getting an opinion of value, it's not technically an appraisal, it's an evaluation. It's not following USPAP. But is there the opportunity or the provision in our law and rule making, or do we have to go back to the legislature? Is this a legal question? To allow for a separate category. And I know the Appraisal Foundation is also talking about this on how they frame USPAP to comply to allow evaluations. Would there be something or an opportunity for us in Tennessee to set out some qualification, minimum qualifications for evaluators, so that they not only understood what our law said, number one, and what they had the content that needs to be in those evaluations, but also understand some basics to perform these valuations. That's not all the hours you have to take to be a licensed certified appraiser, but some minimum threshold. And the banks that are doing this, in my discussions, the banks that are doing this in-house would love to see that as well. They would love to have some qualifications so they had a qualified evaluator in their bank to be able to maybe do that. So that's a solution I thought was worthy of at least discussion or talking about in this conversation about evaluations. So that pretty much, I think Sarah did a really good job of saying, if someone does an evaluation in Tennessee and puts an opinion of value, but they don't put the provision in that this is not an appraisal, then they're actually in violation of the licensure and certification laws, which is, in this case, is a violation of the law, which is they're practicing without a license. So that's a bigger issue, but I think the way you kind of narrow the focus of that issue is bring it into maybe some type of qualifications so that everyone understood the rules that they had need to address here in the state.
I think that's something, I don't mean to kick the can down the road. I hate that. But I really don't think that's under the auspices of this commission at this time.
Yeah, it would
And
have to
maybe
be a
something-
legislative
Yeah, maybe
change.
something that legal could look into and, again, kicking a can down the road, maybe you could bring some kind of information and/or recommendation back to us at our next meeting and
I mean,
say,
do any other states
No.
have that?
No, but of
well,
course,
there's about 6 states that say appraisers, 5 or 6 states that say appraisers can do.
Can do evaluations.
Yeah.
Right, but,
But
there's
nobody's
no
put
like
together-
license as an evaluator
Oh,
or
no,
standards.
I don't
that
know
they-
anything about that. The problem that I have about that, which what Mr. Button brought up, is a lot of times these, and you correct me if I'm wrong, these lenders will hire you because A, they know you're an appraiser, but you're doing something that says this is not an appraisal. But it's kind of like a doctor saying to me, I think you got the flu, but I'm not a doctor. When I know daggone well he's a doctor, and that's the problem that I have with that. And then the other thing is, and Rex and I discussed it while we were talking about it a while ago, is when they say don't sign it or don't put your license number out from when you're doing an evaluation. I'm not exactly sure that that's transparent.
Well, the thing you have to go back to is just go back to the interagency guidelines.
Sure.
And the interagency guidelines are what dictates the content of what needs to be in that evaluation for them to be able to use for a federal-related transaction. It does say that you have to sign that and that you have to acknowledge who the evaluator was. So if they didn't do that, it wouldn't even comply with the rules that they're trying to utilize on the federal side to be able to make it applicable.
So I think our first step that we're going to take, Rex has helped draft some Q&As,
Right.
and we're going to put those up. And along with that, we will have the interagency guidelines posted on our website so that when you go to that page, you can see everything that needs to be out there. And I think that's probably our first big step because it would be a big legislative change to have any. And I don't know that the legislator would like us creating a new designation or license or that comes with cost and a lot of work on our end. So,
Well, I understand that, and the one thing too is maybe that could be handled by someone else that would actually
that-
bring
yeah.
that. And my question is, would you be in favor of it or would you be opposed to it? Because I don't think you would want to try to push any type of legislation. We're not asking you. We're not trying to create more work.
right.
I think what we're trying to do, or what we would try to do with this, is create some more clarity. And are any other states doing it? No. Would be the trailblazer? Probably we are, but we were the trailblazer on a lot of other issues, both the AMC law that we put in place, the evaluations themselves when they came in the current. We were the only state that did that. So a lot of times Tennessee has been the leader on some of these issues and finding solutions to some of these problems, and other states really like what we've done, and they followed in behind us.
Well, and I just mentioned to Roxanne, it would probably be us as a department too talking to financial institutions. We would want to talk
Right.
with them because this may be something that they would house versus us.
It could.
So
And so this is kind of the start of the conversation. It started with Commissioner Bennett and myself talking about this. This was a solution he had. He's not here today. I'm sure he can, kind of bring you up to speed on that as well. But this is something that you would want to do in cooperation with the Bankers Association and others.
All right, thank you, Mr. Button.
Thank you.
I have a few questions. I don't know who to answer, maybe whoever. New kid on the block, so maybe I'm behind the curve here. If I perform as a licensed certified appraiser, if I perform an evaluation and I state this is not an appraisal, am I no longer under this board?
correct.
Correct, you
We
will
have
not.
certain standards
You will
under.
We have no jurisdiction over evaluations.
That is correct.
Okay, thank you.
Yeah, I think is it 6239 104D there's a set of, if you do X, Y, and Z, this is not an appraisal, and therefore it does not have to meet USPAP
Who am I?
requirements.
Who do I answer to now?
No one.
Thank you.
So, so that's what we're coming up with, is we're having people file complaints for evaluations, and we have no jurisdiction over that. So as long as they meet those requirements to be exempt from our statutes.
It would go back to changing USPAP, getting rid of restricted appraisal, call it an evaluation report and an appraisal report, setting out the guidelines and interagency guidelines, and then it would solve it for everyone. I don't, and I've voiced this at Arrow to some. Nobody wants a restricted appraisal, but everybody wants an evaluation. So why not change a format to an evaluation? And now there is some qualifications set forth and some accountability to it. But unfortunately, we would have to wait until 2020 before it would, the earliest that could come about.
Thank you. Anybody else? All righty.
So while we're on this topic, I know those Q&As are on your iPads. I don't know if everybody had a chance to look at them since the last meeting, but if anybody, I know Rex has an addition. You can either say it on the record or just email it to Roxana and I if you want to.
I'll email it. I've got a hard copy that we can.
Okay.
And it's short.
I was explaining to Rex, essentially what we'll do is if nobody else has any additions or changes over the next couple of weeks, I'll review this from a legal standpoint to make sure that everything is good with our statutes and rules, and if there's any citations I need to add and clean it up, Roxana will review it. I'll send it all to you all for a final review, and then we'll kind of route it internally to make sure everybody is okay with it, and then post it on our website.
This question has to do with the certification. Some professional organizations require a certification even if it's not under USPAP, and this would allow appraisers to use that certification and it still be considered an evaluation.
On the evaluations, we'll wait to get any feedback that anyone else has. The sooner the better. That way Sarah can move it on and we can get it ready.
And really, it would be better for us to move this quicker than anything, because it's related even to the ASC letter. They're looking for something out there. And if we could get this at least up on the website and sort of clear up the issue of appraisers doing evals, it may take some of the, give it some relief overall.
I think we're going back now to our last item, at least that I have, and this is on page 47 on your iPads. This is the response letter to the ASC that we have done a draft and gotten at least some of us to look at carefully, and then I emailed it to all the commission members in case we missed something. There was stuff that we knew we wanted to add. It is on page 47 and 48. Mr. Thomas, I know you weren't here at the last meeting, but we've spoken about it. Everyone has seen the original letter that was sent to Mr. Parks and the ASC. They are meeting at the end of January, and so we're putting together a letter that will be tweaked as you all decide now. Add anything. Sarah will make sure everything is stated correctly, and then once it's signed by Mr. Thomas as the chair, it will go directly to the ASC prior to their meeting. So our goal is this week it's got to get to them. When they meet, they'll be reviewing our letter along with everything else, including the waiver requests. Now, they had certain items that needed to be provided to them with the waiver request, and Mr. Parks has done a great job, or Park, letting us know kind of the status. And at least to the best of my knowledge, TriStar hasn't answered some of the things that they were asked to present. I don't know if they have by now, but as of Friday, at least, I don't believe they had.
And you will note, we make note of that in our first paragraph there, that they have not met the requirements of this federal statute, so.
On page, is it 48 or 46? 48, on the first sentence, we've included a table which lays out the number of appraisers by license type in the above cited counties. Excuse me?
Go right ahead, I'm sorry.
as well as in the surrounding counties. I think there should be something at the end. It would be my opinion. There needs to be something at the end of that sentence that says, as well as in the surrounding counties, that would, and I'm not sure of the wordsmithing, accommodate the counties that have been mentioned in TriStar's complaint. Because take Hancock County, for example, there's not an appraiser in Hancock County, but there's certainly appraisals that go on in Hancock County. So there's people outside that are willing to come in, and from the first letter that I read from them, it looked like, we only have this many appraisers in that county that we can deal with. So somehow, if it would be permissible to wordsmith something that says there's not only that number, but there's additional numbers that are willing to come into those counties. I think this is an outstanding letter.
I could reiterate the numbers a little bit for everybody to kind of know. So we only had one public records request by a commission member that wanted to put his thoughts together, and so any information or data given by for any of our programs have to be through a public records request. So that data on licensees was provided, and I reran the numbers to see if we needed to tweak any or all of those numbers. And basically, I went from 409 to 423, and they just went up and down, just small amounts, and in the end, there was a total of one license difference. So I left the numbers alone because these numbers are already with the ASC. It made no difference whatsoever to tweak any of them. So these are the numbers that were given by the public records request in December, on December 5th to be exact, and as of January 12th, they're identical by one. So those numbers all match.
Before we move on, you just want me to add something that essentially says there are appraisers in the surrounding counties that are willing to travel to the cited counties.
Right.
Okay.
Or they can, you have to put, that can service the counties in question, yeah. I don't know who wordsmithed this, but thank you very much. If I'm going to sign it, you sure made me look good.
That's my job.
I was giving all the credit to you, Randall.
That's what happens when you don't show up for a meeting.
Any other thoughts, concerns with the letter? Does it pretty much cover? Okay.
Sounds good.
Okay, that was easy.
And I think that to go back to what Rex and Randy Button were saying a while ago, this is not something that we need to kick down the road. It's something we can take care of, along with the evaluations, because I think that's kind of their avenue out of this. And I think it's going to cause a lot more problems once it's opened.
Well, I think at the last meeting, all of the commission members, definitely that were here, always went back to protect the public, which is what you're trusted to do here. You had major concerns. And so that's the reason we are hurrying and putting a letter together with your thoughts, and we'll get this signed, and then once Mr. Thomas signs it, it'll leave here, and we will just email it directly to Jim Park.
I had one question, and going back on the evals, do we need to vote on that today? No? Okay.
Anybody else? Any additions or subtractions?
I have nothing else, sir.
Any new business? Old business? I'll be happy
Covered the
to.
conference and new business, and we wrapped up the evaluation, so I think we're done.
Okay.
I move we adjourn.
We've got a motion to adjourn. Do I hear a second?
Second.
All those in favor say aye.
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 I've been waiting to use this all day. Meeting is adjourned.
Thank you. Thank you very much.
Oh, you're going to Chicago. All right. Boy, this is a good time to go to Chicago.
Right, there you
Yeah, the
go.
Cubs
So,
aren't
because they are
What?
in our
Cubs
routine
aren't in
share, I
town.
do. I'm in that area